we started out with a couple thousand laws could have impacted landlord and tenants. And then it got whittled down to, somewhere in the neighborhood of 30. And the ones that really impacted the landlords and tenants were somewhere between 20 and 30 laws, if I had to guess on it. But as far as what's coming up since October, what new laws are they contemplating right now? You're talking at least 90 that I've seen. And that's just the very early stages of the session. There are new laws still being introduced, and they're going to continue to be introduced.
Hi, this is Kris German, and welcome back to the Apartment Dealer Show. With us today, we have Mr. Mike Brennan. Now, if you've been an avid viewer of our channel, you know that Mike Brennan is a local practicing eviction attorney, eviction specialist for the last 17 years, representing landlords in LA, San Bernardino, Riverside, all the local counties. And I wanted to bring Mike in as we prepare for our next Apartment Owners Educational Luncheon to discuss what I believe is on the minds of many landlords, a pending change to a law that's actually not just pending, it's changing come here April 1st. And that's the change to the substantial renovation clause within statewide rent control. So for those of you who may not understand, what that is or be aware of it, under statewide rent control, unless your local city has its own layer of rent control, you can actually still give tenants a 60-day notice to ask them to vacate if you plan on doing what under the law is called substantial remodel, substantial renovation. That being, changing things out to copper plumbing or updating the electrical on the electrical panels. Things that would cause you to pull permit work that would take longer than 30 days, you can ask the tenant to vacate. And if you went out and issued that notice today, that's exactly what you'd have to do. It'd be a 60-day notice. You'd have to complete substantial renovation after the tenant moves out. That work that you would move on to do would have to cause you to pull permit, and it should take longer than, say, 30 days. And you have to reimburse that tenant who's vacating their last month's rent of that 60-day period. That's if your notice went out prior to April 1st. If your notice goes out April 1st, well, there's a number of changes, and that's why we have Mike with us here today. And also just to give us a general landscape on where are the tenant-landlord laws now that we're several months and, well, actually a couple of years now, post-COVID. Are things now going back in the direction of a landlord's favor, or where do things stand? That's why we have Mike with us here today. So lock in. This session is going to be very informative. So Mike, welcome back to the show.
Thank you, Kris. I appreciate it.
Now, I wanted to sit with you for a few minutes. Of course, we have our educational luncheon that'll be coming up here in a few weeks. And as we look at the political landscape of California, as we look at the changes when it comes to real estate law, tenant protections, I began to think, we've been putting on this event now for about 16 years. 16 years ago, or the beginning and the dawn of this event, and even within those first few years, there wasn't much to speak on when it came to, say, tenant protections and so forth. And many of the questions that were posed by the attendees and landlords had more so to do with, should I hold my property in an LLC? Or if I'm having an argument with the neighboring owner of property and, those sorts of things. Not too much about the tenants. It was pretty clear cut. If they didn't pay, you'd go to court and they'd be evicted. And not that they weren't at that time putting up habitability, type of stuff. But then since then, slowly as it evolved, first it became the smoking issue came up. Well, now you'd have to make your property a no smoking property. Well, what if your tenant legally is prescribed marijuana? So now you got people smoking marijuana in your units. And then from there, it was the emotional support animals. Well, you had a no pet policy. Now you had to take pets and what that all came to be. And then you couldn't restrict tenants or applicants, depending upon what their income source was. So you had to start accepting Section 8 tenants. And then you get to rent control coming to be in 2019. And then COVID hits in 2020. And then that just seems to have accelerated where we are today up to this point. in terms of tenant protections and how now that pendulum has swung in a tenant's favor. Am I painting that picture correctly? Is that about how this has evolved, or, what's your take?
I think it's a really accurate overview. Everything started kicking in 2008, 2009 with the Schreiber Act, which was the first real heavy form of tenant protections that came about because of the economic downturn. And the Schreiber Act hired a bunch of attorneys in a bunch of counties. That was the start of the whole jury trial demand. But your overview is right on the money. It's just snowball.
We host this event to educate the landlords, and I know that yes, you get paid to represent landlords, but I know you have a real heart for the landlords because you don't want to, you don't like seeing people get hurt in the process, and you see, landlords making wrong decisions and what have you. And so we host this event so that people are empowered, they are informed. And so I thought we'd touch on one topic, of course, that is on everybody's mind, and that's the change to the substantial improvement clause, I'll call it. I know that's probably not the right legal jargon, but within AB 1482, that up to this point, you could give a tenant a 60-day notice to vacate and take back a unit if you were going to substantially improve the unit. And now, come April 1st, that law is changing dramatically. What's going on there?
So you're talking about SB 567. You are right. It goes into effect April 1st. I wouldn't, Kris, I know it's changed, and I'll go through the changes. I wouldn't say it's changed dramatically. I think if a property falls under the Tenant Protection Act, that's the, I don't like any form of just cause ordinance or rent control, but if you've got to fall under one, that's not a bad one to fall under. It's a relatively watered down version of some of the more radical cities like Los Angeles or Santa Monica or something like that. The changes that took place, they may seem significant for some people, and it's more hoops to jump through, certainly, but it's relatively easy to navigate. So let me just walk through what it used to be, and then we'll talk about what it is now. You're talking about a substantial remodel or a demolition, and it's one of several no-fault reasons to terminate a tenancy under the Tenant Protection Act. And the way it was worded before, the basis of that would be you're going to go in and you're going to do work on one of the buildings, either the structure or the system, and the work requires a permit. And that was kind of it. And you didn't even have to pull the permit. It just was work that would require a permit. And you could terminate that tenancy based on a 60-day notice, and you waived 1 month's rent. Very straightforward, very simple. As you can imagine, landlords jumped on that, and they saw the writing on the wall, and they said, okay, we know what's coming. I've said this before. Once the camel's nose is under the tent, you're not getting rid of the camel, right? It's coming in. And so they saw that this was going to be eroded, just like you and I talked about when it first went into effect. And it has been eroded. So now the substantial remodel is still there. It's relatively the same, except now there's some notice changes. There's some language that needs to be in the notice, and there's some more requirements, some more hoops. So what are those requirements? So now, if you want to do a substantial remodel, it's still a no-fault eviction. You still waive 1 month's rent. You still serve the 60-day notice. The difference is you do actually have to pull the permit to do it. And you have to, in the notice, you have to give the scope of work, we would call it. What is it that is you're going to do? Why does it require the tenant be out for 30 days or more? And why can't it be done safely with the tenant in possession of the unit? And so, yeah, that has changed. And in that sense, when you didn't even have to pull the permit before, in that sense, yeah, it's changed quite a bit. But if you think about it, it's really relatively easy. I just had a consultation with a client this morning about this very law. And what we were doing, we were just lining up exactly what they need to do in what order. And so right now, for your listeners or the people who attend the luncheon, I would say, if that's the direction you're going to go, you can still use that. You can still pick up properties, go in with a substantial remodel in mind. You'll be a little bit more strategic about it. You might pick off one unit at a time instead of vacating a whole building, but you're going to work closely with a contractor. The contractor is going to give you a bid, give you the scope of work. And I would encourage your members, your clients, your attendees, if you're going to do that, align with an attorney that can sit down and explain it to you what needs to be in that scope of work, or sit down with your contractor, and they'll write up a scope of work. They'll answer the questions why it can't be done safely with the tenant in there, and why it's going to take more than 30 days. And you're going to go ahead and pull your permits based on that write-up, put that information in the notice, and move forward with your substantial remodel. So yeah, it's more hoops. And yes, there will be more hoops in the future. I guarantee it. But it could have been a lot worse. For example, Pasadena, they've got a substantial remodel. The only difference is you have to let the tenant come back in after the remodel's done at their old rental rate. And that's not what the Tenant Protection Act says. You can actually take it to market, and that tenancy is terminated at that point. So,
okay, so if I could pick this apart, so let's talk about the pulling of the permits. So the law, it says that you have to pull the permits. Does it speak to the fact that you have to clear the permits after the work has been done?
It doesn't. All it says is you have to have the permits.
Okay, so it
says you have to attach the permits
to the notice.
To the notice, correct? Yeah.
Okay, so we'll let the viewers read through the gray, through the lines on that, between the lines on that one. But you have to pull the permits. Doesn't say that you have to clear the permits after the work is done.
It does not, but let me address that since you brought that up, because I think that's a great point you're making. In every sort of a contract or a statute, there is an assumption that everybody engaged will be acting in good faith. So I would caution, clearing the permits, you have to clear them. Not necessarily. It'll depend on the scope of work, how long is it taking. But if there's an element of bad faith there, I would caution people about that, because there are civil penalties for some bad faith terminations, and you can have a city prosecutor come after you. You could have a state prosecutor come after you. You could end up paying attorney's fees. So just a word of caution there.
The second piece to this, Mike, is the verbiage. Now, I could see contractors saying, well, I can write a bid for you that the electrical panel is going to cost X and the copper plumbing is going to cost X and so on and so forth, but not necessarily the exact verbiage that would keep you out of hot water under the ordinance. So say like an attorney like you, would you feel comfortable doing that verbiage, given obviously you're not a contractor, you're not the individual doing the work, or who would the landlord turn to ensure that verbiage about why the tenant has to vacate and why is the scope of work is going to take more than 30 days? If the contractor is not comfortable, who does the landlord turn to? Well,
that's the point I was making when I said align with an attorney. I have done that for clients already. The contractors, they're contractors, right? They don't understand the importance of the way you phrase things or word things, mm-hmm. But being very accurate and precise with the wording is something that I can do once I have that bid from the contractor. So yes, it can be done that way, and it should be done that way.
So Mike, since our last educational event, which took place September of 2023, how many laws have been passed, signed into law that affect landlords? You know our client base, local landlords. How many have been passed?
So passed since September. They were passed before that. That's why I'm struggling with this. They were passed before that. They were passed before the September luncheon. They just weren't signed into law until October. So we've addressed that in the past luncheon. There were we started out with a couple thousand laws that could have impacted landlord and tenants, and then it got whittled down to somewhere in the neighborhood of 30. And the ones that really impacted the landlords and tenants were somewhere between 20 and 30 laws, if I had to guess on it. But as far as what's coming up since October, what new laws are they contemplating right now? You're talking at least 90 that I've seen.
Wow.
And that's just the very early stages of the session. There are new laws still being introduced, and they're going to continue to be introduced all through the summer. And then the legislative session will cut off at the end of the summer.
Now, Mike, I can see the landlords hearing 90 new laws, and they're hoping that that's countrywide, not statewide. So what is it? Is it 90 laws being contemplated by the time you count in federal and local? Is it just state? Is it just city? What are we talking about here when you say the 90 laws?
That has nothing to do with the cities. That's just the state passing legislation, or I'm sorry, the state when I say passing, it can have two different meanings. If it passes out of committee, then it gets voted on. Okay, so you have different committees, housing committee, for example. Mike Brennan, if I were a legislator, I could sponsor a bill and the committee would vote on it. And if they vote on it and it passes out of committee, now it goes up to get voted on by the whole legislative session. And if it passes out of that, then the governor gets to sign it or veto it. So the word passes kind of makes things a little confusing. But you bring up a great point. That's just the state. There's 90 laws that have just been passed out of committee on the state level so far. The city of LA just is never ending, churning things out. They just threw something out. Every month they're throwing something out at these city council meetings. So it's just endless. So you've got that federal level, which the feds are starting to get involved in this stuff now. You've got, which is interesting that you brought up Jamie Dimon, right? Because Jamie Dimon is now whispering in the ear to the White House.
Right.
And so you've got a federal level that's starting to evolve. You've got a state level that these guys are nuts up in Sacramento. And in our case, you've got a very local level where in LA County, the county itself plus the cities are starting to pass their own tenant protection ordinances and things like that. So it's just a hodgepodge of quilts thrown on top of each other.
So it's not just a few laws that a landlord needs to know. There's several that have actually been signed into law by the governor. And then you have nearly 100, we'll just round up here, nearly 100 that are being kicked around and contemplated, all that impact housing. So that begs the question that, these landlords, they're not attorneys. And it's not like when these laws are passed, they're taking out the front page on a local editorial. How are they supposed to know these things? How would one find out? Are they responsible to know, even though they're not getting, say, a notice in the mail about, here, Mr. Landlord, here are these new laws? Do they bear that burden of responsibility to know these things?
Yes. As you've heard your whole life, ignorance of the law is no excuse. And the courts certainly feel that way. To your question, how are they supposed to know the laws? You take it from the top level. Right now, there's not much to know on a federal level because there aren't too many federal laws unless you've got a Fannie or Freddie loan on your property, or you've somehow got either Section 8 or a veterans voucher program or some sort of federal subsidy. If you do, you're going to know about those laws, and you should know about those laws. On the state level, how do you know when those laws are passed? The best way to know is to stay informed. How do you stay informed? Well, you join the organizations, the trade organizations. You show up to educational courses like your luncheon. You surround yourself with articles, websites. You can go to YouTube and watch you can pull up videos about the new laws that are being contemplated or being passed. But it's difficult. There's no question about it. But I promise you will be held to follow those laws. On the local level, I've said this a million times, if wherever your property is located, you should be at those city council meetings, or you should have your manager at those city council meetings, kind of taking notes. If you can't do that, maybe watch them on C-SPAN, do whatever you can. But the city council ones, the city council meetings and the city council laws, things like that, I think you're going to hear less about those in media than you will the state laws. And so you need even more due diligence on the local level than you do on a state level. It's complicated. There's no question about it.
So the bottom line is landlords bear the burden to know these laws, cannot claim ignorance and say, hey, I wasn't sent a pamphlet.
Right.
And so if they cross the line, like say, for example, the new law with regards to security deposits, now you cannot require more than 1 month's rent for security deposit. Well, if a landlord hadn't been to one of our events, they don't belong to AOA, they truly do not know, and they charge their next tenant 2 months, 3 months worth of security deposit to make up for the fact that that person didn't have great credit or didn't have the job history. They're trying to help the tenant. They're saying, hey, I otherwise wouldn't take you, but if you give me some more or if you place some more security deposit down, okay, you know what? I've been there. I'll give you a hand up, so to speak, and get you, into some housing. So the landlord is trying to be helpful. Actually, they just shot themselves in the foot because they broke the law.
They did. That's exactly right. They are held accountable to know and follow the laws. And as you say, Kris, in that situation where they're actually trying to help somebody, I hate to say it, but no good deed goes unpunished. You have to stay on top of all these laws. And by the way, that does happen. And it happens not just to the mom and pops who, they have a fourplex. They're not a member of the associations. They don't stay on top of things. It also happens to savvy clients of mine. The classic example was when the Section 8 issue popped up right before COVID, January 2020. All of a sudden, Section 8 is a source of income. And if you say you don't take it, now you're violating the law. And I had several very savvy clients call me saying, hey, I just got a complaint in the mail from the Department of Fair Employment and Housing because of Section 8. What the heck is this all about? And these guys who own hundreds of units. So it happens to everybody. And unfortunately, like I told them, you're going to have to navigate this because that law went into effect. You didn't know about it. I'll tell you about another one that's very common. January 1st, 2020, Tenant Protection Act goes into place, right? And it's got certain requirements. You have to notify the tenants if you're exempt, and if you don't, you're not. You have to notify the tenants if you are covered by the Tenant Protection Act. Well, 2 months later, COVID hits. And so not a single landlord out there, or very few, actually complied with those notices because they were navigating COVID now, 2 months after the law went into effect. And so every time we open a case and the property would have been exempt from the Tenant Protection Act, the first question we're asking them is, hey, did you serve these addendums? No, we didn't serve the addendum. Okay. So now we have to do that to get you back in compliance with the Tenant Protection Act, just so you can say you're exempt from the Tenant Protection Act. So it's next. If I didn't do this for a living, it would be impossible to stay up on top of this stuff. In fact, I just told my client that I was consulting with this morning, this is part of the reason, Kris, I'm not the active litigator anymore. My associates are in court. I spend a full-time job plus some, just reading this stuff, staying up on this stuff, so I can guide the associates who are going through court and know exactly what issues to look for. I pity mom and pops, and I pity any management professional or real estate professional that owns buildings in multiple jurisdictions that is expected to understand all of this stuff. It's brain damage.
And so with the passage of the laws, that came into effect this year, with the laws that are being contemplated, do you see it at some point where they're going to say, okay, we have caught up the law, so to speak, now to make it more balanced between tenants and landlords, and now we're going to lay off the landlords? They've had enough. And so now we're going to go back to the days where we weren't changing things, every other month. Or do you see this only intensifying?
I see it's going to get a little bit worse before it gets better. The only thing that's going to, so there's different dynamics to this, okay? There's worldwide dynamics. There's a lot going on in the world right now. Could lead to war, as everybody knows. Then there's national dynamics. I just told you the feds are getting involved in this, so it's a growing trend, these tenant protections. I think there's a bigger picture to that. You and I have discussed this several times. We don't have time in this moment to discuss this, but there's a bigger picture why these tenant protections are going into place. In California, on a state level, I see some hopeful light at the end of this tunnel. There's these races for the Senate, for example, that are popping up. Steve Garvey, he's running for office now. He's actually in the running. I mean, he's real. And some of the left-leaning mindset, the people who are leading the charge in these tenant protections, their political position is not guaranteed. And so on a state level, I think we're starting to see some hope. On the local level, I think we're facing the same thing. The only way we're going to see this trend slow down on any level is if we start to vote in more conservative-minded politicians. And you said it correctly. Everything is a pendulum, right? We're swinging really far to the left, and there's reasons for that. Economic dynamics at play that, look, admittedly, a lot of people are having trouble paying their rent. And it's not because they don't have a job. It's not because they're lazy. It's not because there's anything specific about them that makes them unreliable or flaky. That's not the case. It's the economics on a worldwide level, right? Now on a national level. And so now I understand, I'm not saying I'm happy about it, but I do understand how this trend is growing. It's being pushed by a certain political faction. And the way to change that is to change that political faction, change the politicians that are actually passing these laws. Like I said, I think it's going to get worse before it gets better, but I do think there's possibilities to get better. To answer your question, yeah, it is possible. It's probably going to change. The pendulum's going to swing back, at least to some degree. It may not swing back to 2007 when, life was really good and it was easy, but it will swing back so that it's less radical. Because some of these laws that are coming out, even right now, are just one step further than they were last year. I'll give you an example. Perfect example. You actually brought it up in this interview. You mentioned pets. Just before we hopped on the interview, I was reading a piece of paper that got distributed about a proposed law. And this proposed law that's passed out of committee now is going to prohibit landlords from prohibiting everyday pets. So right now you could say, hey, we don't take pets, right? Of course, the tenant's going to go out and say it's a comfort animal. And that's a whole different topic, but you still have the right to say we don't take pets, no pets. And this law that's being proposed right now would prohibit landlords from saying no pets. So it's just snowballing. They've gained steam and they're going to take this as far as they possibly can.
No pets, but at the same time, 1 month security deposit. So if the pet wreaks havoc in the unit, I tell you.
That's your problem. Right. You're going to have to sue them.
Obviously, the premise of our educational event we're going to have here shortly is so that you can do your best job, and at least in the short amount of time given to you amongst the other speakers, to rifle through as many of the most important laws, that you feel that are the main ones that the audience needs to be aware of and to protect themselves. And of course, for discussion that afternoon will be the Justice for Renters Act that's going to be on the November ballot here in California. And maybe for those of you that are watching that are California landlords, or maybe you haven't heard, yes, rent control is going to be on the ballot once again. And you may be watching and saying, well, hold on, we have rent control. We do, but they did not get the bill that they envisioned. So now they're coming back again. And when I say they, the individuals who were behind rent control to begin with, the individuals who funded the first go in 2018. And so we're going to break this apart. And one of the scariest components of this, of course, is vacancy control. You'll be told, should a unit become vacant, how much you can rent that unit for. We're going to discuss what that means. I know, Mike, that you'll come well prepared to discuss that. But again, it's just like you mentioned the quilt earlier. It's just this patchwork of all these various laws the landlords need to be aware of. It makes ownership that much more difficult day by day, and has a lot of individuals questioning, why am I in this again? So
yeah, I mean, if you can navigate it, if you've got those economies of scale we've talked about and you can navigate it, real estate still makes sense. But not a lot of there's a growing number of people that can't navigate it. I want to throw out some numbers just to give you some kind of context for these discussions and the erosion of mom and pops and private property rights. One of the organizations, the trade organizations, prior to COVID, their average membership, the average number of units per member was 8 units. Now, post-COVID, the average number of units per member has grown to 20 units. So what does that tell you right off the bat? These laws are pushing, as much as these legislators say, hey, this law is designed to get corporate America out of housing. No, they're not. These laws are designed to push mom and pops out of housing. So it's the membership, the number of units per member is growing in 4 years. It more than doubled, indicating that it's larger companies that are buying these properties because they navigate it.
That have the staff and the wherewithal financially to deal with all the challenges.
Yep.
Well, actually, Mike, we look forward to you being with us here later this month. We appreciate your participation. I know that the landlords greatly anticipate what you have to share, and it'll be informative as always. So thank you again, sir.
Thank you, guys. I really appreciate you asking me on.
All right. We'll talk to you soon. So there you have it, folks. Almost nearly 100 laws that are being contemplated for landlords. You have to stay in the know. This channel is one of the main places local landlords should be glued to, not because it's my channel, but because as best as I can, I try to bring you that information, bring you the resources that are going to help you in the day-to-day management of your multifamily properties. Now, if you're asking yourself, well, how can we attend this educational luncheon that we hear about? Well, if you could attend, you would have already received an invite either by email or direct mail. And so we invite those who own in the areas that my team and I service, where we represent landlords in the purchase and sale of multifamily properties. Obviously, we'd like to open it to the market at large, but we try to keep it small and intimate so that the attendees can actually ask personal questions to the speakers and so forth. And the data that I go through, especially the market data, only speaks to, again, the areas that we service. So if you own outside that area, you'd sit through half of the afternoon and some of the information just wouldn't speak to you. It would be selfish for us to have you in attendance knowing that. Of course, post-event, we'll share some highlights and I'll discuss on this channel some of the talking points that I think everyone should know. But for those of you that have received your invite and have not registered as of yet, I implore you, there's much to know when it comes to owning multifamily properties. This is not the market of 2 decades ago. Many things have changed, and I want to ensure that you continue to thrive as you build your financial legacy in multifamily properties, as you continue to build that generational wealth for you and your heirs. Let's do it. Let's do it safely. Let's do it under the letter of the law. Let's make sure we don't step in any hot water, any traps that have been set up for us. Make sure to like this video, share a comment. What are your thoughts and feedback on the content shared today? Subscribe to our channel if you have not done so as of yet. Obviously, on our channel, there's almost nearly a couple hundred hours now of educational content, and we only will continue that to provide that much more. I suggest you subscribe to our channel. And as always, this is Kris German, the apartment dealer, wishing you positive cash flow, tenants who behave, and much protection from Uncle Sam. Till next time.